Um, and we are recording as well now. So, first of all, I want to thank our panelists for being here tonight for this discussion. I also want to thank everyone tuning in online. Especially want to thank Nick Loris, who is joining us from Copenhagen. This is true dedication to the cause. He's on a trip, but he decided he couldn't miss this. So, thank you, Nick. For those of you who don't know me, my name is Chris Barnard. I'm the president of the American Conservation Coalition. We are the largest grassroots conservative environmental organization in the US. We were founded in 2017 really to bring conservatives to the environmental, energy, and climate conversation and to represent their views. We have over 45,000 members across the country at over 100 chapters, where we're excited to host conversations like these, which are really important. Most Americans, around 80% actually, believe that climate change is real, and the vast majority of them want us to do something about it. The question is, what do we do about it? Some argue that we should sue energy companies or even governments for climate-related damages, otherwise known as climate litigation. Others say this is not such a good idea and that we should be pursuing good legislative and policy solutions instead. Joining us today to represent both sides of this debate are the four gentlemen who you see here, who will be our panelists for this discussion. We have Professor Michael Gerrard. He's a director at the Sabin Center for Climate Change Law at Columbia Law School. We have Phil Goldberg. He's a special counsel at the Manufacturers Accountability Project. We have Professor Richard Frank, who's director at California Environmental Law and Policy Center at the University of California in Davis. And finally, last but not least, we have Nick Loris, the Vice President of Public Policy at C3 Solutions, or the Conservative Coalition for Climate Solutions. Now, these are some of the top minds in the country thinking about these issues, so we're very honored to have them be joining us tonight, or this afternoon, depending on where you are. But also acknowledging that none of you are here to listen to me talk, so I say let's go straight into the conversation, have a good discussion, and this is how it's going to go. We're going to have each of the panelists start by quickly introducing themselves and their top line quick summary of how they look at these issues. Then Professor Gerrard is going to give a short presentation overviewing the broad climate litigation space. And then I have a bunch of really exciting questions prepared for all of us to dive into and have a really great conversation. So without further ado, Professor Gerrard, let's have you kick off, then we'll go through the other panelists and then come back to you for the quick presentation.
Thanks, Chris. So as you said, I'm a professor at Columbia Law School where I teach courses on environmental law, energy law, and climate change law. And I founded and direct the Sabin Center for Climate Change Law. So my quick response to the question is we need many different things to use to fight climate change. We are way behind in meeting our greenhouse gas reduction goals. Ideally, we would have strong legislation, but that doesn't seem to be in the works. So I think we need a combination of regulations, technological innovation, economic incentives, and litigation of certain kinds, I think, can be helpful. So we need many of these things. It's not an either-or situation.
Great. Thank you. Phil, let's go to you next.
Great. First of all, thank you to you, Chris, to the American Conservation Coalition, and to Michael for helping to coordinate all of this. I am special counsel to the Manufacturer Accountability Project, and like the American Conservation Coalition, we very much believe in dealing with climate change and dealing with it in a very responsible, effective way. Where I think that I agree with the people who are bringing this litigation is that climate change is a serious global problem that needs to be addressed. I think that's without question needs to be done at the global level and at the local level. If we look back at the past 100 years, electrification is seen as probably the greatest advancement in human health and standard of living that we've seen. And so the ability to refrigerate food, medicines, heat our homes, transportation, all those things, our factories, how we have done all of this has been remarkable, but it's also something we can't continue to do in terms of climate change. And so we need to figure out over the next short bit of time, and we've been doing this for the past 20, 30 years, how we're going to change the way we use energy, how we change the way we source energy so that we can both be sustainable for the American people, and also be sustainable, and not just American people, for all people, and for the planet. And that's the challenge that we have before us, and happy to chat about how this all fits in with the litigation.
Great. Thank you, Phil. Professor Frank, let's have you go next.
Right, thank you. Yes, I'm a professor of environmental practice at the UC Davis School of Law, where I also direct the California Environmental Law and Policy Center. I teach a number of courses, including climate change law and policy, like Professor Gerrard. And before I became, and also this is something where Mike and I have a similar career path. I had a first career for 30 years litigating on behalf of the state of California and the California Attorney General's office, where I spent most of my time on environmental and natural resource cases. And in that capacity, had the opportunity to participate in some of the very earliest climate change litigation. And I would just make two quick points at the top. First of all, this is a relatively recent phenomenon of climate change litigation, which I would define broadly. But I think the first case of which I'm aware filed in American courts was probably back in 2002. That's not very long ago. The other thing I would point out from my perspective, I think, is that climate change litigation in 2024 is very much a two-way street. Both environmental organizations and progressive states, as well as more conservative states, red states, and industry and some conservative legal organizations are all utilizing and commencing litigation to advance their particular goals and legal positions in state and federal courts across the country.
Great, thank you. Nick?
Yes, I am the Vice President of Policy for the Conservative Coalition for Climate Solutions. We are a free market think tank in Washington, D.C., where we really focus on lowering the costs of clean energy technologies so that they are widely deployable among both the United States and around the world. I think if you're looking at both the energy poverty challenges that we face around the world, as well as the need for more productivity, more economic growth, we want to ensure that as we address climate change, which we feel is a critically important issue, we need to not lose sight of all of the economic importance of boosting prosperity around the world. And we generally think those things can go hand in hand. And so we look at policy and regulatory ways in which we can lower the cost of a lot of these clean energy technologies. We are very much technology neutral. We think that whatever makes sense economically is what will be widely adopted. And we think there's a lot of different pathways, and it will probably take some combination of technologies that already exist today and some that we may not know exist yet. And so we try to find what are those regulatory and policy barriers that we can fix to bring those costs down and make it in the economic interest of those countries, not just in the United States, but around the world, to develop those technologies and adopt them.
Awesome. Thank you, Nick. Well, again, thank you all four of you for making the time and to lend your expertise to this conversation. And obviously you gave your top line thoughts, but I want to still start by acknowledging that when you say climate litigation, most people kind of scratch their head and don't really know what we're talking about. So I would love to kick it over to Professor Gerrard. He has a short presentation that he's going to run through to just quickly show what the climate litigation landscape looks like. What do we mean when we say climate litigation? And what are some of the recent suits that are being brought? So Professor Gerrard, would love to have you do that, and then we can dive into the discussion.
Thank you, Chris. Can you see my slides?
Yep.
So we define climate litigation as litigation in which climate change or greenhouse gases are a factual or legal component. And so our center at Columbia maintains a database in which we attempt to have all of the climate change litigation around the world. So this is a database. It's freely available to the public. Climate litigation really took off around 2007. There were a few cases earlier, as Professor Frank said, but it really took off around 2007 and increased fairly rapidly through the past decade. In looking at in what countries does it occur, we've counted about 2,400 cases around the world, of which 70% or so in the US. So if you call it a champion or not, the US has the great bulk of the climate litigation in the world. Australia is number 2, the UK is number 3, the EU is number 4, but in all, around 50 countries have some form of climate litigation or another. Of the climate litigation in the US, the largest number of them are brought under the National Environmental Policy Act, NEPA, which is the federal statute that requires assessing the environmental impacts of proposed federal actions, and also a large number under its state counterparts led by California. So these are mostly lawsuits challenging a particular project or decision, saying that there wasn't enough environmental review looking at the climate impacts. A lot of cases under the Clean Air Act, some brought by environmental groups and blue states saying that the government should do more, some brought by red states and some in industry saying the government is doing too much. The most prominent of these cases is Massachusetts versus EPA, the 2007 Supreme Court decision finding that the Clean Air Act covers greenhouse gases. We also have cases under the Endangered Species Act and lots of other laws. Sort of the most prominent ones, and the ones I suspect we'll talk about more today, are the cases brought under common law theories and under public trust theories, and I'll talk more about that in a second. The principal ongoing or expected U.S. climate litigation in the U.S. In the coming year, as I'll say, there are a bunch of cases brought mostly by states and cities against fossil fuel companies for money damages. Just about anything that the Biden administration is doing on climate change is challenged in court, again by the red states or industry as going too far. So there are a lot of these lawsuits pending. There are some pending in the other direction. Under the Trump administration, the cases went in the other direction. It was mostly blue states and environmental groups saying the Trump administration wasn't doing enough. There are lawsuits challenging fossil fuel projects such as natural gas pipelines and LNG facilities. There are lawsuits challenging renewable energy projects like wind and solar. There are some prominent cases brought on constitutional grounds, either federal or state constitutional grounds, and under the public trust doctrine. So last summer, there was a trial in Montana under the state, the environmental provisions of the state constitution, in which the plaintiffs won. That's now under appeal to the state Supreme Court. Of the lawsuits against the fossil fuel companies, the one brought by Honolulu has gone the furthest and has been upheld by the state Supreme Court in Hawaii. The defendants there are asking the Supreme Court to take it on. There's another trial that may happen in Hawaii in July under the public trust doctrine, and possibly one in Oregon. And finally, there are a number of greenwashing claims that companies are saying that they are environmentally sound when they're not. I mentioned the cases brought by states and cities against the fossil fuel companies. So this is the first of 3 slides showing them. There are about 30 of them in all. Almost all of them were initially were litigated for several years on the question of whether they belong in state court or federal court. The plaintiffs almost invariably want to be in state court, the defendants in federal court. For now, they're in state court, and some of them are proceeding. So these are the cases brought by the states and tribes and DC against fossil fuel companies. These are the cases brought by various cities and counties So in all, we have around 30 of these cases, and they raise a number of interesting issues that I think we'll be talking about today.
Yeah, thank you. And it really strikes me kind of as we were going through the introductions here that obviously not everyone on the panel here agrees that this is the best way that we should, or one of the ways that we should be going about tackling climate change, but everyone here does agree that we should be tackling climate change. And I think that's an interesting nuance that we can then play with, be like, okay, what is most effective? And Professor Frank, I'd love to get your thoughts on some of the legal arguments that are being put forward. It's like, okay, people clearly want to do something about climate change and reducing emissions and pollution, but what are the arguments they're actually advancing in the courts? And could you offer your thoughts as to how meritorious you find those from a legal perspective? And then we'll have Phil and Nick talk about that as well.
Well, as Professor Gerrard pointed out, there are so many types of climate change lawsuits. I think some of the most important from a policy perspective as well as a legal perspective, and the ones that are garnering most public attention right now are, again, as Professor Gerrard has indicated, the lawsuits by state and local governments against the fossil fuel industry, which are not challenging any governmental action, but are an effort by the public entities to seek financial money damages from the fossil fuel industry, whom they seek to hold accountable for their emission, the emission of greenhouse gases, which contribute tremendously to climate change. So that is really a cutting edge issue. That litigation trend was pioneered in California by a law firm, Shear Edling, and based in San Francisco, that started this trend by representing several local governments, counties in California. But that has become a broad trend that with local governments around the nation and a number of state governments as well, adopting basically the same doctrines. They rely on state law, generally law of public nuisance, and in some cases trespass, and depending on the jurisdiction, in some case state constitutional claims. They're not monochromatic lawsuits, but as Professor Gerrard mentioned, they were met initially with a strong pushback by the fossil fuel industry that those cases should be resolved in federal court rather than state court under what's called the removal doctrine. That has occupied several years, and I think ultimately those cases, a couple of those cases, went to the U.S. Supreme Court. One brought by the city of Baltimore, and long story short, those cases have all been remanded back to state court for resolution on the merits. And some of those cases also, Professor Gerrard mentioned greenwashing cases. There's an element in a number of those cases, claims that couple the claims for monetary recovery under public nuisance. The idea being that the public entities are forced to absorb a great deal of cost to address the already developing and very costly implications of climate change in an effort to try and tie those to the industry. And added to that, the idea that a number of the same fossil fuel companies have been learning and internally taking the position that, like we've discussed here, that climate change is real, and at the same time having a very sophisticated and broad-based public relations campaign arguing to the contrary, that climate science is unsettled and it's just a theory, et cetera, et cetera. So we're seeing some of those in Massachusetts, standalone greenwashing claims brought by the Commonwealth of Massachusetts, but that's another claim coupled to many of these state law, common law claims. The strongest argument, I think, that the fossil fuel companies, now that they're being forced to actually focus and defend these cases on the merits, is the issue of causation, because how can the greenhouse gases, which are ubiquitous globally, how well or should they be able to be attributable to individual companies producing fossil fuel projects, gasoline, other fossil fuel projects, and holding individual companies, be they British Petroleum or Conoco or Exxon or Peabody Coal Company. So we will see. I think that's their most formidable hurdle, looking at it from as an observer. I will say two things: that the plaintiffs' attorneys who bring these cases seem to be quite confident that they can make that linkage and persuade judges and, in some cases, juries of that causal connection. So I think that's it's going to be interesting to see how those cases play out. The other second bucket of cases are the so-called atmospheric trust cases, which are brought generally by the Our Children's Trust, which is a nonprofit organization, kind of set up these cases, and they are focusing on government for what they believe are state and federal governments inaction in violation of the young plaintiffs' substantive due process rights and under public trust doctrine theories and the like. Those cases have they're farthest along as in some states, as Professor Gerrard mentioned in Hawaii. But we have a trial where they held a case, HELD, young Montana plaintiffs suing the state of Montana for, in their view, not adequately and aggressively addressing the problem. And they are relying primarily on the state constitutional provisions embedded in the Montana Constitution, guaranteeing Montana residents of a clean and healthful environment. They won in the first of these trials. They won in trial court. They're now before the Montana Supreme Court, so we'll see where that goes. And there's a long-running case in Oregon that was filed against the federal government by another group of plaintiffs of young people represented by the Our Children's Trust organization in federal district court in Oregon. That has had a long ping pong legacy everywhere from the federal district court to the Ninth Circuit Court of Appeals to the U.S. Supreme Court and back again. The case remains alive, and the federal district court judge, who has expressed some sympathy toward the claims, and she is very interested in taking the case to trial, and barring intervention by the Ninth Circuit or the U.S. Supreme Court, I think that case is scheduled to go to trial later this year. So we'll see where that goes. And then the third category, and Professor Gerrard dealt with this really well, is really the mirror image of lawsuits brought by red states in the fossil fuel industry against Democratic presidential administrations, challenging climate change regulatory policies undertaken by those administrations on various statutory and constitutional grounds. And the mirror image of that is blue states and environmental public health NGOs, non-government organizations, suing Republican administrations, starting with the George W. Bush administration and more recently the Trump administration, claiming that they are not doing what they need to do, either under the plaintiffs' views of statutory authority or otherwise, to address climate change. So that's and that has really whipsawed back and forth depending on which administration has been in office, and that's been an interesting exercise in political science to observe. But it's really I'm sure it causes a lot of confusion and consternation among judges, courts, observers, and people on both sides of the political debate. I'll stop there.
Yeah, well, thank you for such a comprehensive overview, and I think there's many different directions we can take the conversation in. I want to start by quickly going to Phil, because I know, Phil, like, you've written about this, you've talked about this a fair bit, and I think you have a view that is probably a little bit different, and I'd love to kind of get your take on everything that was just said and kind of how you're looking at these issues and all of that.
Absolutely. And, I think both Michael and Rick did a great job kind of walking through the cases. And the only thing that I would disagree with what Rick said is I think this round of litigation against the private sector really started back in 2004 and was developed with AEP versus Connecticut was the first round of litigation where you had a bunch of states suing the utility industry for causing climate change and seeking federal public nuisance claims and injunctive relief and a whole bunch of stuff like that. But there are other cases where at the same time, there was a village in Alaska that was suing under federal public nuisance law. There were homeowners in Mississippi suing under state law. There was a suit in California against the car industry. And so you ended up with all this litigation. And in 2011, the Supreme Court, in this case we all know by heart at this point, called AP versus Connecticut, said this isn't appropriate for the courts. The Congress has through the Clean Air Act has assigned this to the Environment Protection Agency. It's displaced the federal common law, which is the federal liability law in this area. And that's a good thing, the court said. The court said it's good that EPA is in charge of this because you don't want to have ad hoc case-by-case rulings deciding our energy policy. And so if you look at the heart, I mean, the technical ruling of that was Congress displaced the federal common law. So the federal common law doesn't exist in this area. But it went on to say all these other things about the proper role of the courts and the legislatures and the federal regulators and kind of how each has its own place. There were meetings, and some of this is online. It's reports and all that about how the people kind of behind this said, okay, so how do we now try to use the litigation to try to drive climate policy? And I'll stop and say that I remember. God, I want to say it was like 2009 or 10. I first came across Professor Gerrard at Valparaiso Law School, which unfortunately no longer exists, and they had a symposium called "Litigation's Role in the Path of U.S. Federal Climate Change Regulation," and I was speaking there on this very topic, and as was Professor Gerrard, and then there was a full acknowledgement that what they were trying to do was use the litigation. When I say they, I mean, so the activists that were behind this, to use the litigation to regulate emissions directly. And so when they went back after the Supreme Court said, no, you can't do that, they said, well, how do we do it? So the entire strategy that was developed, and again, this is all published online. It's nothing that I have any specific insight into, was saying, okay, let's ask state courts to award money damages to local constituents as opposed to trying to go to federal courts. And so they developed this whole state court and state law approach based on, as Professor Frank said, on public nuisance, some consumer protection, some trespass. And they've kind of gone that route. And much of the past, and that litigation started filed in 2017. And then I don't think Vic Scher was originally one of the firms that was involved, but ultimately he did get involved, and he probably has much of the litigation at this point. And so he's obviously very well associated with the litigation. And so what we've seen over the past 5 years is a little bit of jockeying, as you said, about which ballpark do we play in? Are we in the federal court ballpark? Are we in the state court ballpark? And at this point, we are in the state court ballpark, and now they're trying to figure out, well, what law applies? Does federal law apply? Does state law apply? And so that's the key issue in the Honolulu case, which before I was be on this panel, and in about 30 minutes when I get off and to go back to writing my amicus brief that is due on Monday in that case in the Supreme Court, explaining why it's federal law that has to govern. Because what Hawaii is saying is, there may have been, communications, marketing, production, and all of this around the world. And we want to say in Hawaii that violated our law, and you got to pay us damages here in Hawaii. But very little of that actually happened in Hawaii. And so, Baltimore and California and Boulder and others are saying the same kind of thing. We want to apply our liability law to conduct that happened not just in our own jurisdiction, but outside of our jurisdiction, in other states and other countries. We don't really care where it happened. We want to subject it to our laws. And the U.S. Court of Appeals for the Second Circuit, in a very similar case, when in response to New York City's lawsuit a few years ago, said you can't do that. That's not how the law works. These are issues that are not appropriate for state law. They're federally. Whenever you're dealing with interstate issues like that, you have to yield to the federal law, and the federal government determines what how we deal with those things and how we resolve those kinds of interstate disputes, and especially when you deal with international issues, where you have a lot of national energy security issues, that it's important that we allow the federal government to kind of drive those issues. There's one in the case in Delaware, the Delaware Superior Court said, kind of followed that line of thinking and said, because the state of Delaware brought one of these suits and said, you can only sue for things that happened in Delaware. You can't sue for things that happened in New Jersey or Maryland or anywhere else. And so, in that case, is now kind of working its way through. But that's the embodiment of what this issue is about. Can you sue only for the things that happened in your state, or can you say we should be able to sue, these companies for things that happened anywhere, anytime, by anybody? And so that's kind of what is going before the Supreme Court over the next few months in terms of the legal issues. Now, when you get to the practical concerns and the things that on behalf of the manufacturing community that we care about, this litigation is not going to solve climate change. I mean, and it's right there in the complaints themselves. And they try to say, like, okay, you can still sell fuel, you can still do it. We're not trying to impact in any way your ability to do that. We just want you to pay us money for the impacts that climate change is having on our communities. And there's just no legal foundation for that premise under whether it's public nuisance law, whether it's state consumer protection acts. That's not, we heard about the causation concerns that Professor Frank raised, but it's also the underlying law. It just doesn't apply to this situation. And so I think we're years from actually getting to courts to actually look at that. But ultimately, I think they're going to decide there is no public nuisance here that the companies are responsible. There is no Consumer Protection Act claims that are viable here, and go through all of that. That's just what it is. It's really just a state law veneer that is trying to mask the fact that they're trying to get around that 2011 Supreme Court ruling, AB versus Connecticut. And if they say no, if they're in federal court, the federal courts are going to apply AB versus Connecticut like the Second Circuit did and knock these cases out. So the only path that they see is we got to stay in state court. So we got to figure out how to, and under state law, in order to try to get state courts to say, if I can award money from these, these national companies or international companies to my constituents, that's a good thing for me. So I think ultimately that's what they're trying to bank on. The other problem we have with this is that this is an incredibly undemocratic way to set national energy policy and the impacts of national energy policy. You look at the national security impacts and what we've, all the effort that's gone into making sure that there is proper production with the Russian invasion of Ukraine and other global conflicts. This administration has said we need more production of these fuels right now in order to do that. You have these lawsuits are going to counter that and say that are going to tie the hands of the companies from doing so. The other thing, it's going to drive up costs. And in fact, some of the people behind this litigation have said that's actually their goal. Their goal is to, in quotes, raise the price of fossil fuels and of what it costs on our electrical bills, what it costs to put fuel in our cars, what it costs to power our factories. They want to raise all that cost because to them, that's their way of trying to impose a cost on our use of energy. But they're not looking at how much that cost is going to be, who's going to pay for it, where that money gets spent. Those are all legislative issues where we need the checks and balances of the Congress and the legislative process to make sure all of us are considered in how that comes out. And so that's why those decisions are really policy and legislative decisions, not liability decisions for the courts. And so, I think at the end of the day, the frustration that we have is that there's been a trend, not just in the climate space, but generally speaking, when there's a political issue of concern or there's a societal issue of concern, to try to sue companies to try to get money from them to solve that, to pay for that. And the companies may just be involved in that space, but that's not the role of these companies, first of all. And it's not good for consumers to do that because it's going to make everything more expensive for us if that's how it goes. And especially when these suits, by the way, are not naming, the foreign energy get state-owned energy entities like in Saudi Arabia or China or Russia or India. These are all just doing our own, the people who sell us this energy. So we're all going to pay more, and around the world, they're not going to. And so that's just going to shift energy production by economics to those entities. And the New York Times wrote this article about a year and a half ago or so, explaining all of that, saying as US companies are bringing down their production of these fuels, the OPEC countries are increasing their production of all these fuels. And OPEC share of the market go from 55%, where it is now, to 75%. And we're going to lose a lot of control over that. And they don't care about fighting climate change the way we all do on this panel. And so that's going to make things actually worse in the long run. And so, Chris, sorry if I went on for a little bit longer than I should have, but you got me all riled up. But that's kind of what our concerns are about this litigation and why we think this isn't the right way to go.
Yeah, well, let me quickly loop Nick in here. He's been very patient, but then I'd love to kind of get Professor Gerrard and Professor Frank's thoughts on what you just said. But it strikes me that there's a legal dimension to this conversation of like, okay, you can argue like they should be in state court or a federal court, and like there's the legal arguments to be had on both sides. And I'm not a lawyer, so I'm not necessarily well qualified to formulate thoughts on either side of that. But then there's also what you raised, Phil, about is this even effective at tackling the problem? And I think, Nick, you mentioned in your introductory remarks that like the goal of C3 Solutions is to advance free markets as the way to do something about this problem. And the fundamental kind of premise of that being that if you can make a technology economically competitive, that's how you're going to advance it. And that seems to me like a juxtaposed way of looking at it compared to a litigation perspective. So I'd love to get your thoughts on like what you just heard, but also how you guys are thinking about like the best way to tackle these kinds of problems.
Yeah, just a few comments. And as I think the only non-lawyer other than you, Chris, I'll keep my remarks pretty short. But yeah, I think that's one of my biggest concerns. And, as Phil mentioned, you're not just outsourcing production of energy, you're also outsourcing those emissions. And if you are outsourcing that emissions and production to countries who are exploiting resources in ways that violate, public safety, that violate human rights, but also do it in much dirtier ways, you are not reducing emissions. And so not only do you have the higher costs associated as a result of this litigation, but you also are not reducing emissions. It's not changing the demand side of the equation. And to the extent that the United States is reducing its supply of its resources, you're largely just increasing emissions overall. I think some of the other concerns that I have is, one, I think one of my biggest takeaways from Professor Gerrard's presentation was just how litigious the United States is and how that is a huge obstacle toward the adoption of clean energy technologies. And I think, a lot of folks on the right have been worried about, litigious activists stopping the development of energy projects. And now a lot of folks on the right are using the same tools that the folks on the left did to stop the energy projects that they don't like. And so we're seeing this for transmission, we're seeing it for wind and solar. It's going to happen for nuclear, for geothermal, all of the, kind of NIMBYism that we've seen historically, I think is just going to be put on steroids. And that's a big problem. And that's not to say we shouldn't have some sort of judicial review that, NEPA can't be used in an effective way. And we should have necessary community engagement to make sure that communities aren't being exploited. But we also need to do so in a way that actually builds things, whether that's clean energy projects, natural resources, critical minerals for mining and processing, or, even things like housing. So that's the first point. The second point is this issue of causality. I think that's a really important one because as we think about anthropogenic emissions, we know that anthropogenic emissions are driving warming, but there was uncertainty in the science, even looking at the Intergovernmental Panel on Climate Change's reports. You look at the equilibrium climate sensitivities and what a doubling of CO2 emissions would do for global surface temperatures, and for the first 40 years of the report, it was largely the same. There was uncertainty in a range of 1.5 degrees Celsius to 4.5 degrees Celsius. And even in the fifth assessment report, it only said that they were attributing about half the warming from 1951 to 2010 to anthropogenic emissions. And so it wasn't until this latest report that they said nearly all the warming is from anthropogenic emissions. And so there was some uncertainty in the science, and you did have, companies like Exxon, employing some of the, world-class climatologists, many of whom worked on the Intergovernmental Panel of Climate Change reports. So I think there's a difference between trying to, hide the science or obscure the science and fighting policies that would hurt their bottom line. They may acknowledge that climate change was happening or even was a risk, but they're also still going to fight policies that may not necessarily be in their economic interest to do so. But getting more specifically to this causality issue, I think it's very difficult. And Ted Nordhaus just had a recent op-ed in the New Atlantis saying, did Exxon make it rain today? Which I think is worth checking out. But it is really difficult to attribute one specific company or even industry's impact on things like extreme weather, on warming, or even trying to attribute climate damages to a community. There's differences in, what the monetary figure for the social cost of carbon is, that it's very difficult to understand what emissions specific impact may have on an extreme weather event. And so one, how do you try to figure that out? And then how do you try to compensate those communities? I think is a very difficult thing to do. And again, I think this is part of the broader conversation of climate change litigation, but who are the defendants then? It's obviously not just the energy companies, but it's also, you could go after the agriculture industries, you could go after individuals who drive cars and use fossil fuels to light and heat their homes. You go after the federal government, whose policies, oftentimes are welcoming the development of natural resources. And so all of these things, I think, make it very complicated and difficult and costly to actually drive and effectuate change. Where again, where we focus, and to your point, Chris, is I think this is a bit of a costly distraction, in my opinion. And so I'd rather focus on good policy that can help drive down the costs of these technologies and make it easily for them to deploy them. Some of that is permitting reform, but there's a whole litany of policies at the federal and state level that I think will help drive down the costs, even more so, of some of the nascent technologies that we're trying to develop today. But also we have mature technologies that are cost competitive with fossil fuels. How can we get them online faster? There's so many different ways in which we can do that without litigation. And that will ultimately make this, it won't, but it should make this challenge of litigation go away.
Thanks, Nick. I feel like you dropped a lot of different things there, so I feel like I'll let the lawyers in the room pounce on any of that they want to pick up on, or anything that Phil said before that, because I know that he had some counter arguments as well.
So if I can, if it's okay, I'll start by just saying a few things. The effort is indeed to reduce the demand for fossil fuels, not only to change the supply. The most important thing that could be done to reduce the demand for fossil fuels is move to electric vehicles. And the red states are litigating against the efforts of the Biden administration to have stronger standards that will drive cleaner vehicles and ultimately electrification. And that many of them are also fighting the energy efficiency standards that also seek to reduce demand. With respect to the litigation, the AEP case explicitly, the Supreme Court explicitly left open the question of whether the state common law could apply. They held that the federal common law of nuisance does not apply to greenhouse gases, but they left open whether state common law could apply, and that's what the new cases are under. The AEP case, as you said, also was calling for an injunction where the district court would be mandating levels of emissions from power plants, and the new cases don't do that. With respect to the claims that are brought, Honolulu is saying that the defendant companies in Hawaii deceived Hawaii consumers, and that had negative effects on the climate of Hawaii. So clearly the it came from global actions, but they are specifically challenging conduct in Hawaii. Whether they or the other plaintiffs will be able to prove the necessary degree of causation, we will see. None of the cases have gotten nearly that far. There are some calculations that attribute a certain amount of greenhouse gas emissions to the fossil fuels extracted by certain companies. I'm sure that'll be litigated. It's certainly true that the litigation, the emissions come from all over the world, but none of the courts have gotten anywhere close to that issue. On the issue that this is a fundamentally undemocratic way to set energy policy, I think what the plaintiffs are saying is the democratic processes so far have failed us massively, and that we are on a pathway to climate catastrophe, and that we need to use whatever legal tools are available, and that these lawsuits are among the legal tools. But if we just leave it to the elected politicians, we know that in the US and in every other country, they're not doing enough. So if we leave it purely to Congress and the president and so forth, we're just not going to get there, and we're going to have a catastrophic impact. So that's why so many of the activists are looking for a broader array of legal tools. The final thing that I want to say on with respect to free markets is that one of the bases for the theory of markets is that externalities need to be internalized, that you can't impose costs on others without paying for it. Putting greenhouse gases into the atmosphere and other pollutants is now free. That is a massive market failure. One way to correct that would be to impose a social cost of carbon. And of course, the red states are challenging that as well. It's not free markets. It's markets where pollution is free. And that's the opposite of what a free market really would be.
I could just piggyback onto what Professor Gerrard said. But first, let me just point out there are precedents here responding to Phil's comment about the aspect of the climate litigation that he's focused on, brought by states and local governments and the like. There are a couple of precedents here. First is the tobacco litigation that was not commenced by the federal government, but by a coalition of both Republican and Democratic-led states that I think was proceeding to trial, and I think I'm a little biased here because I was in the California Attorney General's office and we were one of the leaders in that coalition, that bipartisan coalition. But I think it's very likely we would have prevailed had this case gone to trial. The tobacco industry, I think, saw the legal writing on the wall and chose to settle. So in that case, at least in its preliminary stages, according to the tobacco industry and its supporters, is a lot same kind of causation hurdles and what have you that were surmounted. More recently, and this is more of a California phenomenon, the public health hazards of lead paint led to the city of San Francisco City and County and Santa Clara County in Northern California suing the lead paint industry for the public health hazards associated with their products, which had not been internalized. And that case went to trial, highly publicized. And despite the lead paint industry's efforts to beat the causation or lack of causation drum in that defense, the court ruled against them. And though both of those legal initiatives, I think, had a profound impact on public policy in those areas of environmental protection and public health in particular. Professor Gerrard talked about the internalization of costs, and I agree wholeheartedly with his talk that this is profoundly anti-market, the way that the costs of greenhouse gases and the attendant consequences on our world and our environment are not internalized. The other thing is, turning to Nick, I would just say that, and Michael touched on this, but I'll be a little more less diplomatic about it. With our current dysfunctionality in Congress, and Congress cannot get anything done. And I look back wistfully on the 1970s when we had a bipartisan and fully functional Congress passing a whole slate of environmental laws very controversial and consequential topics: Clean Air Act, Clean Water Act, the waste issues, Endangered Species Act. We don't have that now. And there's those who say we ought to leave this to the political branches of government rather than the judicial branch, are overlooking the fact, or maybe just ignoring the fact that I don't think anybody I talk to from any point on the political spectrum believes there's any reasonable prospect of getting any climate change legislation done through Congress. And then the other ultimate irony here is that the executive branch, which both in recent Republican and Democratic administrations has tried to do things unilaterally in the face of congressional refusal to deal with climate change issues, tried to work unilaterally. And recently, 2 years ago, it was the regulated industry that advanced the so-called major questions doctrine, which the U.S. Supreme Court adopted, which really limits the ability in the face of congressional inaction of the executive branch to take on, using its executive powers to address these problems, in this case, climate change. And so and that was the West Virginia versus EPA case. So it was red states and a number of fossil fuel industry allies that really advanced successfully, I might add, before the Supreme Court, the ability that the presidency, the executive branch of government, is constrained from taking an aggressive effort unilaterally to address these climate change issues. So come back to endorse Professor Gerrard's point that in the absence of any meaningful congressional or executive action, it's no wonder and perfectly understandable to me and predictable that advocates on both sides of the climate debate are going to seek access to the court to pursue and hope and achieve their goals.
Just to be clear, I'll just jump in real quick because I know we're running out of time. I don't have a whole lot of faith in policymakers either, but I don't have a whole lot of faith in the courts. I think my faith is in the private sector and the companies that are motivated to reduce emissions. And if you look at companies like Google, who are looking to procure clean power 24/7, they're not just buying carbon credits anymore. They're actually looking to procure green power 24/7. 365 days a year. I think those are going to be the motivating factors that drive down the cost of clean energy technologies and electric vehicles, which are, I think, prohibitively expensive for a lot of people. And you can look at the lifetime costs and fuel savings, but for people who can't afford to pay a $15,000 premium upfront for an EV, that's a real cost, and that's a real barrier to entry for EVs. And I love EVs. I'm hoping that we can drive down the costs, and would agree that we don't have a free market by any means when it comes to energy policy. My point was to say that trying to calculate those external costs are very challenging to do so. We do have a number of regulations, whether it's CAFE or on power plants. I think that there's over 80 regulations from the federal government that include the social cost of carbon in their cost benefit analysis. So it's not to say that we don't have take into consideration the social cost of carbon, but that number fluctuates greatly depending on what your consideration of the discount rate is, what your consideration of the equilibrium climate sensitivity is, anywhere from $5 a ton to a couple $100 a ton. And that makes it really difficult to say what that social cost of CO2 should be, especially if you're looking at it from a global perspective.
It's funny, I was listening to Professor Frank talk, and he was wistfully remembering the 1970s when Congress actually functioned. I worked on the Hill in the 1990s, and I always wistfully think back to then when Congress at least had to they actually passed appropriations bills and authorization bills somewhat on time. Now we don't really do any of that. And my line about that is, we didn't care what party you were from if you were working on the Hill. We only cared if you were at the party with us that night. We hung out, we got to know each other, and we worked with each other across the aisle as the way to get things done. And so, I think we're all frustrated by the lack of action in Congress, and we're all frustrated by any meaningful solutions. But that doesn't mean we take what are congressional issues and legislative issues and to just go try to do it somewhere else. If we don't have in this country a legal system based on internalizing into certain products or activities all of the external costs. And so if we are going to do that here, we have to do it in a forward-looking way. We have to do it through Congress. We have to do it where we can have hearings where you can look at what are the impacts, how much it should be, and all the things that go into determining those kinds of issues. And Canada did something like that a few years ago and ultimately pulled it back because they realized it wasn't workable the way they had designed it. But at least it was designed some way that the legislature there did that. Going to the courts and using liability law, that is retroactive. That's looking backwards and saying, well, we're just going to assign a liability to you for doing this, even though that's not what the law was, when you did it. And so I remember, oh gosh, probably about 10 years ago, again, I keep calling out Professor Frank, but when he was talking about the lead paint litigation in California, I was doing a panel like this. We actually were in person because it was before this whole Zoom world took over, with judges in California. And we're talking about the lead paint case. And what was clear was the judges in that litigation wanted to solve the problem of lead poisoning in children and didn't apply the law the way it was in California at the time. And unfortunately, the California Supreme Court didn't take the case, and so we don't really know what California law would say. But the Court of Appeal, the district judge, said, "Look, I want to solve this problem." And what was fascinating was in that room of judges, there was this intense debate that broke out in the audience about what the role of judges are. And you had probably about 70% saying, balls and strikes, this is what I'm going to apply the law the way it is. And then you had about 30% saying, well, if there's a problem and there's someone in the room that could pay for it, I'm going to make them pay for it. And it was just this fascinating back and forth that, the panelists and I, we just stopped talking because they were going. But it really has a lot to do with where we are, I think, in this litigation is you have laws and rules of the road and to abide by. And if we need to do something and change those rules to address climate change in many of the ways in terms of internalizing costs, then we need to do that the right way. I think this litigation doesn't necessarily do that because it's just going to make the energy more expensive for us, but not in a way that's strategic and that's thoughtful and that takes into consideration all the things that that kind of impact should.
Well, if Congress is the right way, I'd love it to do that. But the fact is that the fossil fuel industries are providing massive contributions to the members of Congress who are blocking action. And since action is blocked, and since Congress is not acting, it hasn't acted for years, it's necessary for the people who want to save the climate to use whatever other lawful means are available. Litigation is one of the lawful means that is available. The litigation is putting more pressure on the fossil fuel companies to try to move much faster toward a transition. A lot of them are slowing down their effort to transition away from dirty fuels. I think more pressure needs to be put on these companies, and we just cannot rely on a captured Congress.
Well, on
Couple
that,
of points about judges and climate change that I just want to mention. A number of court systems, I think, so in the federal judiciary, and I know here in California, our state judges they're anticipating that for better or worse, they're going to get more of these climate change litigation cases, and they want to be better trained on the science, the economics, and other aspects. So they're doing training courses for judges in this area to deal with the complex science and other issues. So I think that's most welcome. The other thing is that in the Juliana case that we were mentioning, one of the atmospheric trust cases that is currently before the federal district judge in Oregon. Previously, it went up to the Ninth Circuit Court of Appeals, the U.S. Ninth Circuit Court of Appeals, and there's a fascinating 3-judge panel. 2 judges voted in favor of the federal government finding concerns with that case going forward, and there was a most passionate dissent by the other circuit judge on that panel. And I teach that case to my students, and I ask them to read both opinions very carefully, the majority opinion and the dissenting opinion. And it really frames that kind of division within the judiciary that Phil alluded to. So it's placing the judiciary, federal and states, in a sometimes uncomfortable position.
You know, part of the problem is that the courts just don't have the tools. They're trying to make a decision about climate policy based on the parties and the allegations that are before them. They can't have hearings and look and consider other stakeholders, other issues, you know, anything other than the rules of evidence and the parties in front of them. And that's just not how this is not how policy should be made when we're talking about these kinds of broader societal issues.
So I don't want to get too far into the legal weeds here of trial, but particularly in the federal courts, often overlooked is the fact that when you're dealing with complex issues of science or economics, judges have the ability to hire their own advisors, known as special masters, to provide hopefully unbiased technical support. And as someone who's done some judicial training here in California and for the federal judiciary, I think that's an underutilized tool that they would be wise to utilize in the complex, fraught world of a climate change law and policy.
Look, I know you lawyers will continue to argue tonight, but it's late in Copenhagen, and Nick needs to rest for a day of tourism tomorrow. But I really appreciate all four of you for the time. And honestly, I thought this was a really edifying conversation. It's not one that's necessarily the easiest for people to understand, but I think you all did a great job of breaking down the various components, and there was healthy disagreement and a healthy representation of different views here. So thank you very much. We'll make sure to send out an email to everyone who registered to watch this with the recording, but also with a few links to each of your respective work and anything that you might have published that people might be interested in learning more about. But without further ado, just want to thank you one more time for being here with us and for all the work that you do.
And I'll
Thank
put
you.
a plug in for
Thank you.
the Sabin Center's database on the cases. It is top notch. So if you look at any of those cases, just type in climate case chart, which is I do regularly, and there's come up first. So they do a great job of cataloging the cases.
Thank
Awesome.
you.
Here.
Well, on behalf of the American Conservation Coalition, thank you all to those who watched from home and for those of you who joined the panel. And I'm sure we'll see each other soon again.
Thanks, Chris.
Thanks.
Thank you.